massive misrepresentation and manipulation by uploading fictitious results where they were polling units why they alleged there were no elections. Incorrect results
I want to know which way Nigeria is heading to. Every little thing that goes wrong, we start to blame the government. We know everything that goes wrong because we are part of the government. Let's save Nigeria, so Nigeria. Inefficiency and indiscipline is ruining the country now. Corruption here, there, and everywhere. Inflation is soaring high. Let's save Nigeria, so Nigeria won't die. Which way Nigeria? Which way Nigeria? Which way to go? Which way to go? I love my fatherland. Oh, sure, sure. I want to know. Yes, I want to know. Was our doom. Some people now have everything, while many, many have nothing. Let's save Nigeria, so Nigeria won't fall. Which way Nigeria? Which way Nigeria? Which way to go? Which way to go? I love my fatherland. Oh yeah, I want to know. Yes, I want to know. Which way Nigeria? Revolution is a reality. Let's give it a chance to grow. Let's join our hands to farm the land so we can have enough food to show. Let's save Nigeria, so Nigeria will...
28, 29, 30, 31, 32, 34, 35, 36, and 37 of the petitioner's reply to the first respondent's reply are either a rehash of the facts already averred in the petition or contain new facts which will amount to amendment of the petition. In respect of the petitioner's reply to the second and third respondent's reply to the petition, the latter are seeking for an order striking out paragraphs 8 to 42 of the petitioner's reply. However, a careful examination of those paragraphs shows that only paragraph 21 of that reply has raised a new allegation against the first respondent of attempts to manipulate the data uploaded on the back-end server of the AWS. The said paragraph 21 of the petitioner's reply to the second and third respondent's reply is hereby struck. Similarly, the petitioners have introduced new facts in paragraphs 16, 17, 18, 20, 22, 23, 24, 25, and 27 of the reply. 16 sub 1 of the first schedule to the Electoral Act, those paragraphs are also hereby struck. And that indeed is the rulings on the respondents' objections, various objections.
Well, as I was trying to explain earlier before we went for the break, we'll take all the judgments. After that, my learned give their own decisions on the petitions in order to save time. the petitions are consolidated. So now we will go to the main petition, petition number 3. In bringing this petition, the petitioners who were contestants in the presidential elections held on 26 February 2023 have challenged the declaration and return of second respondent as the winner of the election and sought for the declaration and consequential reliefs, which I have reproduced in the beginning of this judgment. The petitioners have predicated their petition on the 3 statutory grounds earlier stated. Although in the ruling of this court on the objections of the respondents, some paragraphs of the petition replies have been struck out for stated reasons, this court will take into consideration the entire affirmance in the petition in determining the merit or otherwise of the petition in the interest of justice. At trial, the petitioners opened their case with tendering from the bar several certified true copies of electoral and other documents which were objected to by all the respondents, who reserved the reasons for their objections to the state of final address. The said objections were therefore admitted, the said documents were therefore admitted and marked as exhibits without prejudice to the objections of the respondents. The court ordered the respondents to file separate addresses on their objections along with their final addresses. In proof of their petition, the petitioners called 13 witnesses who gave evidence as PW1 to PW13. Of those witnesses, only 3 had their witness statements on oath filed along with the petition, while the other 10 were subpoenaed witnesses whose statements were filed separately after hearing in the petition had commenced. The respondents objected to the competence of the subpoenaed witnesses to give evidence and adopt their addresses, witness statements on oath, and reserve the rulings for their objection to the state final address. Without prejudice to the objection, the said witnesses adopted their respective witnesses' statement on oath, after which they were duly cross-examined by all the senior counsel for the respondents. Upon closure of the petitioner's case, the first respondent, as well as the second and third respondents, called one witness each in their defense. The fourth respondent did not call any witness, but opted to rely on the evidence already adduced by the other respondents that elicited under cross-examination on behalf of the fourth respondent. At the close of evidence, parties filed and exchanged their respective final addresses in support of their various objections which they raised during trial. So we shall now consider respondents' objections to the competence of some of the petition witnesses and to the documents tendered by them during trial. To save time, we skip the addresses of counsel and we go to the resolution of those issues. The resolution of the respondent's objections to witnesses and documents is contained in page 84 of the judgment. On the first segment of the respondent's objection, all the respondents challenged the competence of PW3, PW4, PW5, PW6, 7, 8, 9, 10, 11, and 13. And the respondent's essential contention is that the witness statements on oath, whose on oath of those witnesses of the petitioners were not front-loaded along with the petition, but were only filed during trial, contrary to paragraph 4, sub 5B of the first schedule to the Electoral Act 2022. Section 285, sub 5 of the 1999 Constitution as amended, which limits the time for presidential election petition, provides as follows. An election petition shall be filed within 21 days after the date of the declaration of the result of the elections. In the same vein, Section 132, sub 7 of the Electoral Act 2022 provides as follows. An election petition shall be filed within 21 days after the date of the declaration of the result of the elections. Paragraph 4 of the first schedule to the Electoral Act 2022 stipulates the contents of an election petition which shall be filed. In particular, paragraph 4.5 of the said schedule mandates as follows. The election petition shall be accompanied by a list of the witnesses that the petitioner intends to call in proof of the petition, b, written statements on oath of the witnesses, and c, copies or lists of every document to be relied on at the hearing of the petition. But subparagraph 6 of that paragraph, a petition which fails to comply with the above requirements shall not be accepted for filing by the Secretary. Paragraph 14 sub 2 of the same first schedule to the Electoral Act then provides as follows. After the expiration of the time limited by A, Section 132 sub 7 of this Act for presentation of the election petition, no amendment shall be made. 1. Introducing any of the requirements of paragraph 4.1 contained in the original election petition file, or 2. Effecting a substantial alteration of the ground for or the prayer in the election petition, or 3. Except anything which may be done under subparagraph 2A, Roman 2, affecting a substantial alteration of or addition to the statements of facts relied on to support the ground for or sustain the prayer in the election petition. And sub B, paragraph 12, for filing the reply, no amendment shall be made. 1. Of the seat or office by the petitioner is correct or false. 2. Except anything which may be done under the provisions of paragraph 2A, Roman 2, effecting any substantial alteration to, in, or addition to the admissions or the denials contained in the original reply file, or to the facts set out in the reply. The above quoted provisions of the Constitution, Electoral Act 2022, and the first schedule thereto have been thoroughly considered by the Supreme Court in several cases, including Okian, another versus Mimiko, and others, by Ogumbi, JSC, Oba, and Vincent, Ararume, and others, and Anik, Okuru, Ogi, and others, PDP, and Okuru, and several others listed here. In Oke and Mimiko, the apex court by Ogumbi, JSC, held as follows in the court. By paragraph 4, 1, and 5 of the first schedule to the Electoral Act, the composite analysis of an election petition has been spelled out, and also a list of materials which must be accompanied. The use of the word shall in the subsections is very instructive, mandatory, conclusive. In other words, the provisions do not allow for additions, and hence, the procedure adopted by the appellants in seeking for an extension of time is nothing other than a surreptitious attempt to amend the petition. This is obvious from the nature and substance of the application, especially where one of the grounds seeks to put in facts which are allegedly not available allegedly not available at the time of filing the petition, but only came into their possession after the statutory term limit allowed for the presidential election petition. Expressly, there is no provision in the legislation which provides for extension of time. What is more, video paragraph 14.2 of the first schedule to the Electoral Act, the appellant by section 134 of the Electoral Act had been totally foreclosed from any amendment, which was in fact the hidden agenda promoting the application. The saying is true that even the devil does not know a man's intention. It can only be inferred from the act exhibiting that which is conceived in the heart and mind. The use of the word shall in paragraph 14 sub 2a of the first schedule to the Electoral Act is mandatory and places a complete bar on any form of amendment to a petition file and does not allow for an exercise of discretion whatsoever. Further still, on a critical result of the application, relief 2.6 court seek to call additional witness to which AEO. It is pertinent to state that at the close of pleadings, parties had submitted the list of witnesses who were to testify together with their depositions. The idea, purpose, and intention of the application is suggestive of nothing more but a clear confirmation seeking for an order of an amendment as rightly and ingeniously thought out by the trial tribunal and also affirmed by the lower court. This will certainly violate the provisions section 285(5) of the Constitution and section 134 laws of court. In his concurrent judgment in the same case, Nguta JSC specifically stated as follows, I quote, the additional or further witness depositions sought to be allowed for a just and fair determination of the petition are fresh facts found by endorsed by the lower court. This court will not interfere with a concurrent finding of fact of the two lower courts when the appellants have failed to show a special circumstance for this court. Are time-bound and the court will not allow a party to resort to any sort of subterfuge or to frustrate the intention of the Electoral Act. The petitions disposed of expeditiously. The petitioners in this case have relied on the earlier versus Ete and Lasun versus Awoyemi Supra to argue that the subpoena witnesses whose witness statements on oath were filed outside the time limited for the presentation of the petition are competent to testify because they are subpoena witnesses who do not work for the petitioners. However, it is pertinent to observe that unlike in the present case, the subpoena issued at the instance of petitioner in the case of Omidran and Ete and Lasun versus Awoyomi were decided under the Electoral Act of 2006. Provisions similar to paragraph 4 sub 5, first schedule Electoral Act 2022. Secondly, the subpoenas in the above two cases were issued and served on adversaries, namely the resident electoral commissioners. Again, those introduction of section 285 subsection 6 of the Constitution of Federal Republic of Nigeria 1999, which mandates that an election within 180 days from the date of filing of the petition. Thus, whilst this court in Omidran and Ete and Lasun versus Awoyomi appeared to have adopted a flexible approach, the apex court had taken a strict approach in its latter decision in Oke and Mimiko. Indeed, in subsequent following the apex court's decision in Oke and Mimiko, this court, per Agim JSC, as he then was, now JSC, highlighted this strict position of the law in Ogba versus Vincent, paragraph 46 to 48, paragraph 8 to B, wherein he held as follows, I quote, I think that this court in Omidaran and Ete and the Supreme Court in Oke and Mimuko adopted different approaches in addressing the issue of whether a tribunal or court can allow a witness deposition or other document not filed along with the petition or not filed within the time allowed for filing election petition to be filed and used in an election petition proceeding. Omidaran's case did not strictly enforce the time limits prescribed in Section 141 of the Electoral Act 2006. The provision in the first schedule thereto on prohibiting the introduction of additional facts in the proceedings after the period allowed for filing the petition and closure of pleadings, and paragraph 1 sub 1 of the Election Tribunal and Court Practice Directions of 2006 on the content and form of the petition. It held that the purpose of the practice direction is to guide and regulate compliance with and observance of the provisions of the first schedule to the Act and the Federal High Court rules where applicable. This elastic application of the electoral laws by this court in that case is not in line with the current judicial approach of strict enforcement of electoral laws and the current approach of applying the Electoral Tribunal and Court Practice Directions as overriding the rules of court in election cases. In Miko, the Supreme Court approached the issue in keeping with the current judicial trend of strictly applying electoral laws and procedural rules and giving them supremacy over rules of court in election cases. The Supreme Court has consistently, in a long line of cases, insisted on this strict and inelastic approach in enforcing the electoral laws. The law has laid out testimony juries in Oke and Mimiko is that a witness deposition that is not filed along with the petition within the 21 days allowed for filing the petition cannot be filed in the proceedings. It held thus, if there was an evidence which was fundamental to the termination of the petition, that evidence ought to have been placed willy-nilly before the tribunal within the time limit specified by the Electoral Act or any other act. That evidence ought to be regarded as the spinal cord of the petition. Even if it has been withheld by any person, there are several ways to go about placing same before the tribunal. The Evidence Act is very clear on this. The petitioners ought to have restored to that procedure, laws of court. The firm position of the Supreme Court, as stated in Okia Mimiko and followed by this court in Oba and Vincent Supra, is that by the combined provisions of Section 285(5) of the 1999 Constitution, Section 137, Subsection 7 of the Electoral Act 2022, and paragraph 4, 5, and 6, and 14.2 of the first schedule to the Act, every written statement on oath of the witness which a party intends to call must be filed along with the petition within the time limited by Section 285(5) of the Constitution of Federal Republic of Nigeria as amended, and Section 132, Subsection 7 of the Electoral Act 2022. Once the time limited for filing of a petition has elapsed, the contents of the petition cannot be added to or amended in any manner or under any guide. Outside that 21 days limitation will amount to a surreptitious amendment of the petition and a breach of paragraph 14 of the first schedule to the Electoral Act 2022. This is irrespective of whether the witnesses to be called are ordinary or expert witnesses and whether they are willing or superior witnesses. Since then, this has been the consistent position of the law followed by this court. Indeed, in Okuru versus Obe, this court stressed this position by our learned brother Bolaji Yusuf Jesse stated thus, a quote, from the records, PW3 and PW4 was summoned by subpoena issued by the tribunal and presented as expert witnesses. The question is whether this without more entitled the appellant to file their statements on oath outside the time set for filing a petition, or a reply to the respondent's reply in answer to the petition. I am of the humble view that whether an expert witness or not, a witness remains a witness. Though the proviso to Order 3, Rule 3, Sub 1 of the Federal High Court Civil Procedure Rules 2009 made applicable to an electoral First Schedule to the Electoral Act provides that the statements on oath of witnesses requiring subpoena from the court need not be filed at the commencement of the suit. 2. The witnesses who require subpoena or summons shall, at the instance of the party calling them, be served with civil from 1A before the filing of the statements of such witness. The application of that rule is with regard to and or subject to the provisions of the Electoral Act, not independent of the Act. Paragraph 54 reads, subject to the express provisions of this Act, the practice and procedure of the tribunal or the court in relation to an election petition shall be as nearly as possible similar to the practice and procedure of the Federal High Court in the exercise of its civil jurisdiction, and the civil procedure rules shall apply with such modifications as may be necessary to render them applicable having regard to the provisions of this Act, as if the petitioner and the respondent were respectively the plaintiff and the defendant in an ordinary civil action. The provisions of the Electoral Act being a substantive law shall override any rule of court which is contrary to its provision. The subsidiary legislation must conform with the principal law, CNNPC and Afamfa Oil Limited. The proviso to Order 3, Rule 3.1 of the Federal High Court Rules 2009 cannot override or affect or whittle down the absolute and mandated provisions of Section 285, Sub 5 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, which stipulates that an election petition shall be filed within 21 days after the date of the declaration of the result of the elections, and paragraphs 4, sub 1, 5, and 14.1 and 2 of the first schedule to the Electoral Act, which stipulate the content of a petition. It is therefore clear that in law, the provisions of Order 3, Rule 3.1 of the Federal High Court Civil Procedure Rule 2009 cannot provide a platform for filing and using witness statements on oath not filed within the time limit set for presentation of petition, and which time cannot be extended for any reason under any guise. The focus of our decision in Ogba and Vincent Supra was the injustice in allowing a piece of evidence not covered by the pleadings to be presented to the court when the opposing party would have no opportunity to react to it. It is my humble view that the position of the law, as can be gleaned from the Section 2855 of the Constitution, paragraph 4, 14.2, and 16.1 of the First Schedule to the Electoral Act, is that a petitioner cannot be allowed to file and use documents or witness statements on oath filed outside the time set for filing petition, and to which the respondents would have no opportunity to react. To do so will amount to creating an avenue which a petitioner can use or exploit to overreach the respondents. That is the stand of the Supreme Court in Oche and Mimiko, number 1 Supra, followed by this court in Oba and Vincent Supra, close of court. Again, in Ararume and another, but and Anik and others, in which I wrote the lead judgment, they are stated as follows. The law, therefore, is that the deposition of a witness must accompany the petition at the time of filing the petition. In other words, the written statement on oath of an intended witness must be filed along with the petition. Thus, any written deposition of a witness not filed along with the petition will not be countenanced by the court or tribunal. It therefore means that a written deposition filed by a witness not listed in the petition nor his deposition front-loaded cannot be countenanced by the court or tribunal after the expiration of the time prescribed for the filing of the petition. I think that is what the tribunal decided in this case, in line with the decision in Oba and Vincent. The combined effect of paragraph 4.5, Roman 1 and 2, 14.1 and 3 of the first schedule to the Electoral Act is that no witness can testify in chief before a tribunal if he has not deposed a written statement on oath, which must necessarily have been filed along with the petition. Close of court. From the foregoing judicial decisions, it is clear that in election petition litigation, whether the witnesses which a party intends to call are ordinary or expired witnesses, and whether they are willing or supine witnesses, their witness deposition must be filed along with petition before such witnesses will be competent to testify before the tribunal or court. It is instructive to observe that one of the leading senior counsel for the petitioners in this petition, Nyechi Ipiazu, SAM, was the lead counsel to the second respondent in Ararume and another versus Anik and others, wherein he successfully challenged the competence of a subpoena witness, Ama Ibom Agu, PW2, on the same ground that the witness statement on oath of the said witness was filed on 8/7/2019, long after the time limited for the filing of the petition. Therefore, the petitioners in this case were well aware of the settled legal position on subpoena witnesses in election petitions, stated by the Supreme Court and by this court. Yet they embarked on subpoenaing PW3, PW4, PW5, PW6, PW7, 8, 9, 10, 11, and 13. 10 out of their 13 witnesses, whose witness statements on oath were not front-loaded along with the petition. The petitioners have tried to argue that the said witnesses are witnesses of this court. With respect, this argument is misconceived because the subpoena in respect of those witnesses were issued upon the request of the petitioners. The applications for the issuance of the subpoenas were duly signed filed at the registry of this court by the petitioner counsel, and the requisite fees paid, including filing fees and service fees as assessed, were duly paid by them before this court approved and issued the subpoenas. Therefore, those witnesses are the petitioner witnesses and not witnesses of this court. Indeed, the procedure for calling of witnesses by the court is by summons as stipulated in paragraph 42, sub 1 of the first schedule to the Electoral Act 2022. By the provisions of that paragraph, the tribunal or court may summon a witness as a witness who appears to the tribunal or court to have been concerned in the election. It is clear from the provisions of that paragraph that it is a person summoned by the court so motu in exercise of its powers under paragraph 42(1) that is a witness of the court and not a person subpoenaed at the request of a party to the case. In the instant case, PW3, who was subpoenaed at the request of the petitioners, is the staff of Channels Television, who attended exhibits PBH3 and PBH4, and a consultative meeting with leaders of political parties held on 26 October 2022. An interview with Mr. Festus Okoye, National Annual Commissioner, held on 12 March 2023, respectively. PW4, a professor of mathematics who was engaged before the election by the petitioners and whom the petitioners presented as a subpoena expert witness, stated under cross-examination by the first respondent that he concluded his report on the 19th of March 2023 before the petition was filed. PW5 is a staff of Arise Television who also tendered exhibit PCG2, a flash drive showing the INEC chairman delivering an address at the Chatham House, London, UK, on the preparations for the 2023 elections in Nigeria. PW6 is a staff of African Independent Television AIT, who tendered Exhibit PCH1, a flash drive of the program Democracy Today, anchored on 22nd November 2022, wherein the ANIC chairman was shown giving a brief on the preparations for the 2023 general elections. PW7, who claimed to be a cloud engineer and architect working with Incorporated, tendered exhibits PCJ3A to F, which are 6 reports of Amazon Web Services AWS Health Dashboard, which she said she downloaded from the Amazon website. Under cross-examination, however, she not only admitted that she is a member of the second petitioner. Please, let us be serious, please. This is a serious matter, it's not a laughing matter. She not only admitted that she is a member of the second petitioner, the Labour Party, but she had contested elections as a candidate for the second petitioner for House of Representatives elections, conducted along with the presidential elections on 25th February 2023. PW8, who claimed to be a cybersecurity expert, engaged by the Labour Party on 10th March 2023, stated that he produced his preliminary report on 17th or 18th March 2023 before the petition was filed. He tendered Exhibit PCK1, a metadata. PW9, a staff of Women and Child Rescue Initiative, a non-governmental organization, claimed to be an observer in the 25th February 2023 election, but stated that the subpoena was addressed to him personally and served at his village address. PW10 claimed to be an ANIC ad hoc staff who acted as a supervisor. He stated under cross-examination that the subpoena was addressed to him personally. PW11, who is a staff in the Legal Services Department of National Information Technology Department Agency, NIDA, stated that the subpoena was addressed to him personally instead of his organization. As for PW13, who claimed to have acted as a presiding officer in the 25th February 2023 elections, he stated that he was on subpoena. The subpoena, which was admitted as Exhibit PCR, was, however, addressed to him personally and not through INEC. It is pertinent to observe that the above 10 witnesses subpoenaed by the petitioners were all witnesses beyond controversy, that the witness statements on oath of those witnesses filed after the time limited for presentation of the petition had lapsed are incompetent, and the same witnesses had no virus to testify in this petition. Their testimonies are embodied in their respective witness statements on oath, being incompetent are accordingly struck out. With regard to the respondents' objections to the admissibility of documents tendered by the petitioners, the first objection raised by the respondents is to exhibits tendered through PW4, as to exhibits tendered through PW4, 5, 6, 7, 8, and 8. These are exhibits PCD1, PCD2, PCD3, PCE1, PCE2, PCE3, PCE4, and PEF2, tendered through PW4. Exhibits PCG1 and PCG2, tendered through PW5. Exhibit PCH1, tendered through PW6. Exhibits PCJ1, PCJ2, PCJ3, A to F, and PCJ4, tendered through PW7. And PCK2, tendered through PW8. The said exhibits are, I have estimated them in this judgment. The respondents' essential argument is that since the subpoenaed witnesses and their witness statements on oath are incompetent, the documents tendered through those witnesses cannot be countenanced by the court. By paragraph 41(3) of the first schedule to the Electoral Act 2022, oral examination of witnesses is not allowed. Witnesses are only to adopt their respective written depositions and tender in evidence all disputed documents or other exhibits referred to in their depositions. By paragraph 4(5)(b) of the schedule, certain depositions of the witnesses must be filed along with the petition. Since the above exhibits are documents, including expert reports, which were taken through the subpoena witnesses whom we have already declared incompetent because their witness statements on oath were filed in violation of the mandatory provisions of paragraph 45B of the first schedule of the Electoral Act 2022, the documents admitted through them, which form part of their evidence, are inadmissible and liable to be exchanged from the record. See the case of Buhari and INEC. The petitioners have also argued that since the parties have agreed during pre-hearing session that documents properly certified by INEC will not be objected to, and the said documents were tendered from the bar pursuant to pre-hearing order of this court of 23rd May 2023, the parties are bound by what has not been appealed against by the second and third respondents. However, this contention of the petitioners does not represent the position of the law. It is stated that a court is not permitted in any event to admit an act on it is stated that a court permitted to act in any event to admit an act on legally inadmissible evidence, even if such evidence had been admitted by agreement of the parties or under order of court in the course of hearing. Once admissible, when giving its final judgment, even if that will amount to overruling itself by so doing. Ishanu and Afribank by way for JSC. Indeed, even in the case of Sani and Akwe, relied upon by the petitioners, this court at paragraph 20, paragraph B2A, restated the position of the law that even when pieces of evidence had been improperly received in evidence, the trial court as well as appellate court have the power to expunge it from the record and decide the case only on legally admissible evidence. On the objection of the respondents to the admissibility of the documents tendered as expert reports by the petitioners, which were admitted as exhibits PCD1 to PCD3, PCE1 to PCE4, PCJ2, PCJ3A to F, and PCK1, the respondent's contention is that they are caught up by the provisions of Section 83, subsection 3 of the Evidence Act 2011, having been contrived for the purpose of this petition. It is settled law that as provided in Section 83, subsection 3 of the Evidence Act 2011, and pronounced upon in several decisions of the appellate court that a document which is made by a party interested in a pending or anticipated proceeding involving a dispute as to any fact which the document tends to establish is inadmissible in evidence. Thus, in Ladoja and Ajimobi, where the Supreme Court, by Peter Odili, JSC held as follows, I quote, in respect of what is referred to as a person interested, I shall refer to the cases of Nigeria Social Insurance Trust versus Cliffco, Nigeria Limited. As regards to the phrase, a person interested, I agree with the respondent that the phrase has been examined in the case of Ivan versus Noble, where a person not interested in the outcome of an action has been described as a person who has no temptation to depart from the truth, one side or the other. A person not swayed by personal interest, but completely detached, judicial, impartial, independent. In other words, it contemplates that the person must be detached, independent, and non-participant, and really not interested which way in the context the case goes. Normally, a person who is performing an act in official capacity cannot be a person interested under Section 91, subsection 3, which is now the Section 83. I think the phrase, a person interested, ever more so, has been quite definitely put in the case of Halton and Halton to mean a person who has pecuniary or other material interest in the result of the proceeding, a person whose interest is affected by the result of the proceedings and therefore would have no temptation to pervert the truth to serve his personal or private ends. It does not mean an interest in the sense of intellectual observation or an interest purely due to sympathy. It means an interest in the legal sense, which imposes something to be gained or lost. CPC and Ombugadu, when considering and determine who is a person interested under Section 91(3) of the Evidence and Truth and Health does. By the provision of Section 91(3) Evidence Act, a person interested is a person who has a pecuniary or other material interest and is affected by the result of the proceeding and therefore will have have a temptation to pervert the truth to serve his personal or private ends. In fact, it is in its most recent decision in Oetola and another versus Annex, the Supreme Court, per argument, restated this position in the following words. The other evidence adduced by the appellant to prove their case is the expert analysis report prepared by PW1, who by his own admission is a member of the second appellant and had been a special assistant to the first appellant and was engaged by the appellants to establish the invalidity of the disputed results in Form EC8A for the 744 polling units. It testified further that I made the report as directed by the petitioners and that I am part of those who wrote the petition. By his own testimony, he established that he was not an independent expert, as he had an interest in the subject of his analysis and carried out the analysis from the conclusion that the results were invalid to justify to support the contemplated election petition. It was an analysis from an answer and not from a question. Such a report is not the product of an independent, impartial, detached, and professional analysis. He is clearly a person with the disposition or temptation to depart from the truth. A listing of the expert analysis report in the petition among the documents to be relied on to prove the petition show it was made in anticipation of contemplation to be filed. The report having been made by PW1 as a person interested in the subject matter of the petition, when the petition was anticipated to establish that the election result was invalid, is not admissible evidence by virtue of Section 833 of the Evidence Act 2011 as amended. Close of court. In the instant case, PW4, who claimed to be an expert, was contracted by the petitioners before the election to carry out data analysis on the results of the presidential elections held on 25th February 2023. He even tendered his letter of engagement by second petitioner dated 20th February 2023, which was admitted as Exhibit PCF2. According to him, he produced initially 2023. His report was made a day before this petition was filed on 20th March 2023. Obviously, the report Exhibit PCD1 to PCD3 was prepared in anticipation of this petition. As for PW7, who also claimed to be an expert witness, she admitted that she was not only a member of the second petitioner, but had contested the House of Representatives election under the platform of the second petitioner, which election was conducted the same day with the presidential election on the 25th of February 2023. She also admitted that the report she presented in Exhibit PCA are public information posted by Amazon, which she downloaded from Amazon. Open access information she did cannot be amended by her. This shows the not maker of the said documents. As for PW8, who claimed to be a cybersecurity expert, he stated under cross-examination by the first respondent he was as an expert on 10th March 2023 and that he produced a preliminary report on 17th and 18th of March 2023 and final report, Exhibit PCK1, at the end of May 2023, while this proceeding was pending. It is therefore evident from the above that PW4, PW7, and PW8 are personally interested in the outcome of these proceedings. The reports produced by PW4 and PW8 qualify as statements made by persons interested in anticipation or during the pendency of this petition. As for PW7, she is admittedly an interested party, having been a member of and even contested election under the umbrella of the second petitioner. Her interest is further underscored by the fact that she admitted that she was attending court throughout the proceedings prior to her evidence. By virtue of Section 83, Sub 3 of the Evidence Act 2011, the reports tendered by those witnesses which form part of their evidence are inadmissible. In view of the foregoing, Exhibits PCD1 to PCD3, PCE1 to PCE4, PCF to PCG1, PCJ1, PCC. In view of the foregoing, Exhibits PCD1, PCD3, PCE1 to PCE4, PCF to PCG2, PCH1, PCJ1, PCJ2, PCJ3F, PCJ4, PCK1, and PCK4 tendered through the incompetent PW4, 5, 6, 7, 8 are hereby expunged from the record of this court. The second aspect of the respondent's objection is on the ground of improper certification or authentication. PCC 28, which include Adamawa State, are actually diverse reports and their certificates of compliance. That of Adamawa is PCC 21. In short, no certificate of compliance was produced by the first respondent in respect of Exhibits PBP1 to PBP21. The blood IRF reports Exhibits ECA series in respect of Adamawa State. However, since the documents were stated to have been downloaded from ANIC's IRF portal and were certified by ANIC as true copies of what they have in their IRF portal, the documents qualify as public documents within the meaning of Section 102 of the Evidence Act 2011, and the certification by ANIC authenticates those documents. Therefore, the provision of Section 84 of the Evidence Act is not applicable in this case. This is the position of the law as espoused by the Supreme Court in the case of Kubo and Dixie, where the Apex Court held that the computers of internet-generated documents printed from the website of a public institution is a public document, and only a copy of such document which is duly certified in compliance with Section 104 of the evidence at 2011 is admissible. For that, I've started the victim of the Supreme Court by Carl's JSC in support. Exhibits PBP1 to PBP21 having been downloaded from INEC report and duly certified by INEC are clearly admissible. As for the fourth respondent's objection to Exhibit PCG2, the flash drive tendered by PW5, its statement on oath not only stated that he participated in all stages of the recording, production, and packaging of the flash drive, but he had certified the process of his production as required by Section 84 of the Evidence Act. On the fourth respondent's objection to the admissibility of Exhibit X2, on the ground that the Exhibit X2 was obtained by the petitioners from the Register of this Court and not from the custodian of the original copy, we have examined Exhibit X2, which is the European Union Election Observation Mission Nigeria 2023 final report, as rightly observed by the fourth respondent. The photocopy of the document is certified by Secretary of the Presidential Election Petition Court and not any officer of the European Union Election Observation Mission, which is the custodian of the original copy of the document. By Section 104(1) of the Evidence Act 2011, the secondary evidence of any public document is only admissible in evidence if it has been certified by a public officer having custody of the original copy of the document, who by that section may give a copy of same to any person who has a right to inspect, together with a certificate written at the foot of such copy that it is a true copy of such document or part of it as the case may be. Under subsection 2 of that section, the public officer is enjoined to certify same by subscribing his name, official title, and date, and why he is authorized to use a seal with his seal. Clearly, the registrar of this court, who is not the custodian of the original copy of Exhibit X2, cannot validly certify that document under Section 104(1) of the Evidence Act 2011. See Omisori and Arebeshola, Emmanuel vs. Umana, where Mwezi JSC stated that the whole essence of the court's insistence on the scrupulous adherence to the certification requirements of public documents is to vouchsafe their authenticity vis-à-vis the original copies. Since Exhibit X2 has not been validly certified, it is inadmissible in evidence. Accordingly, Exhibit X2 is expunged from the record. The third aspect of the petitioner's objection to the petitioner's document is on the ground that the petitioners failed to plead specific facts to cover the documents objected to. The said documents objected to by the respondents are exhibits. There are so many, they have been listed in this judgment. Get the judgment, you will see them. I have carefully examined the petitioner's pleadings and the documents objected to by the respondents. The petitioners have specifically averred in paragraph 101 of the petition that they will be relying on all the first respondents' electoral and all other necessary documents used for the conduct of the presidential election, including the documents which they listed as items A to CCC of that paragraph. However, election petitions are sui generis, and it is settled that for an averment in an election petition to be competent, material facts relating to complaints made therein must be pleaded. See Belgore and Ahmed, Ipiazu and Oti. In the latter case of PDP and ANEC, the Supreme Court was categorical on this mandatory requirement of specificity in averments of election petitions when the court held as follows. On whether the affected paragraphs were rightly struck out, I have read the affected paragraphs and found that they relate to allegations of non-voting in several polling points, disruption of election, non-conclusion of election, tampering of ballot papers, falsification of election results, widespread disruption, irregularities and malpractice without providing particulars or the polling units where the alleged malpractice took place. The lower court was therefore right when it held as follows. The paragraphs above, in my view, are too generic, vague, and lacking in any particulars, as they are not tied specifically to any particular polling unit or any particular number of people who were alleged to be disenfranchised. The fact that a party can file further particulars or deny in a reply the vermin in the pleading must not be general, it must be specific as to fact. It is certain law that a petitioner's obligation to plead particulars of fraud or falsification, without which the allegation is a non-starter. I have nothing to add to this statement of law as advanced above. I adopt it as mine. Close of court. That's why allegations of non-compliance and corrupt practices are made, such as in the instance the polling units, wards, or other places where those irregularities and malpractices are alleged to have occurred must be specifically pleaded. The petitioners have argued that the issue of non-compliance by the first respondent to its laws, guidelines, and relevant statutes is a universal complaint because it is an infraction against the Nigerian people and the Nigerian state. However, this contention of the petitioners is not in consonance with the requirement of the law as espoused in Belgore and Ahmed, PDP and INEC. This is more so as the petitioner's allegations of non-compliance is interwoven with allegations of corrupt practices, and the same set of facts are pleaded for both. In the instant case, the petitioner tendered the following documents, which have been listed in this judgment. However, a look at the entire petition shows that no single petition or complaint was made by the petitioners in respect of any of those cases as to make those exhibits relevant to the petitioner's case. For instance, in paragraph 72, to which the petitioners referred in response to the objection, the petitioners have alleged that there was overvoting in the states of Ekiti, Oyo, Ondo, Taraba, Oshun, Kano, Rivers, Borno, Katsina, Kwara, Gombe, Yobe, and Niger states. However, the petitioner failed to specify the polling units where the overvoting took place, the total number of accredited voters, the total number of votes cast, and the number of votes to be deducted from the scores of the parties. Similarly, in paragraph 73, which was also referred to by the petitioners in their response to the objection, the petitioners have averred that based on the uploaded results, the votes recorded for the second respondent did not comply with the legitimate process for computation of the result and disfavored the petitioners, and listed the states of Rivers, Lagos, Taraba, Benue, Adamawa, Imo, Bauchi, Borno, Kaduna, Plateau, and other states of federation. But the petitioner failed to state the scores improperly computed and how they were disfavored. As regards the objection to exhibits PCE1 to PCE4, said to be 18,084 and 88 blood results downloaded from RF and contained in 4 boxes, the petitioners have contended that the petitioners' request for the petitioners to specify the 18,088 polling units to which those blood reports led is an impossibility because the results are unreadable and the details of most of the polling units are stated in exhibits PCB1 to PCB3, the expert report tendered by PW4. This contention of the petitioners is, however, misconceived. This is because the petitioners who claim that they could not specify the polling units in the 18,088 blood results because those results are unreadable are the same persons who have stated that the said polling units have been specified in the expert report of PW4, through whom the blood were tendered. However, PW4 stated under cross-examination that the primary source of the data he used in producing his report was the IRF portal. Did not state how he was able to determine the particular polling units and the impacted votes, accredited voters, and the number of PVCs collected. As I earlier noted, PW4's report was concluded on 19th March 2023 before the petitioners filed this petition on 20th March 2023, which means the petitioners were aware of the polling units to which their complaints relate even before they filed the petition. So their theory of impossibility, which they invented around the 18,088 flood results, is misconceived and an obvious misadventure. Again, in paragraphs 7 and 8 of the petition, the petitioners admitted that they have agents in the polling units, and those agents signed and collected duplicate copies of the result sheets. Those paragraphs read as follows. Paragraph 7. The petitioner is a body corporate with perpetual succession and in sponsorship of the first petitioner, and the conduct of the election thereof, acted through its members duly appointed as agents at all stages of the election, namely at the polling units, the ward collation centers, the local government collation centers, the state collation centers, and the ultimate collation center at the federal level in Abuja. Paragraph 8. In the conduct of the election, the agents duly appointed by the petitioners performed their assigned and statutorily designated roles at the election. These roles included observing and monitoring the process of arrival of election materials where they were supplied by the first respondent, and leading to and including the process of accreditation, voting, counting of votes, and announcement of the results of the election. These agents were the election proceeded in due form upon the first respondent agents duly entering the results in the result sheets at the polling units, signed and collected duplicate copies of the result sheets. Having clearly admitted that their agents signed and collected duplicate copies of the result sheets, their contention that they are unable to determine the polling units from which the blood results emanated is untrue. In fact, this admission reinforces the need for the petitioners to specify all the polling units in respect of which they made complaints, since their agents were availed with copies of the results of the polling units. As regards the petitioner's contention that they have complied with paragraphs 4, 5C, and 41.8 of the first schedule to the Electoral Act 2022, I had earlier considered this argument of the petitioner while resolving the respondent objection to petitioner's pleading, wherein we held that the provision of paragraph 4, 5C of the first schedule to the Electoral Act 2022 only relates to the front-loading of documents to be relied upon by the petitioners as their evidence during trial. It does not obviate the mandatory requirement for pleading materials as stated in paragraph 41(1)(d) and 2 and 41(8) of the same schedule, so as to enable the adverse party to know the exact case he is to meet and to respond to same accordingly. As I stated in my earlier ruling, the report which the petitioner stated they had detailed the polling units was not filed along with the petition, so as to afford the respondent the opportunity to respond to same, but was merely tendered at trial, by which time the respondents had no opportunity to respond. Since the petitioners have failed to specify in the petition the polling units to which exhibits PCA1 to PCA4, the 18,088 ballot results relate, the said documents are clearly inadmissible. The said exhibits are hereby discountenanced and expunged from the record. We now go to petition objections to the respondents' documents. In the course of trial, the petitioner also objected to the documents tendered by the first and second and third respondents at the hearing of the 4th of July 2023. The first respondent had tendered exhibits RA1, RA2, RA3, RA4, F5, 6, and 7 through its sole witness, Dr. Lawrence Bayode, a deputy director in the ICT department of the first respondent, who gave evidence as RW1. Of those documents, the petitioners had objected to the admissibility of exhibits RA1, RA2, RA6, and RA7. Similarly, at the hearing of the 5th of July 2023, the petitioners had objected to all the documents tendered by the second and third respondents from the bar and through their sole witness, Senator Michael Opemi Bamidele, who testified as RW2. The petitioners had reserved their reasons for the objection to be adduced at the stage of final address. Pursuant to the order of this court, the parties should file separate addresses on their objections. The petitioners have filed separate addresses in support of their objections to the documents of the first respondent and those of the second and third respondents. The written address in support of the objection of the first respondent documents was filed on 23rd July 2023, while that in support of the objection to the second and third respondent documents was filed on 20th July 2023. In the written address in support of the petitioner's objection to the first respondent document, Dr. Olivier Uzoku, the learned senior counsel for the petitioners, essentially raised the sole issue of whether, having regard to the pre-hearing report of 23rd May 2023, paragraph 41, sub 3 of the first schedule to Electoral Act 2022 and other relevant provisions of the Act and decided cases, exhibits RA 1, 2, 6, and 7 are inadmissible and liable to be exchanged from the evidence. Similarly, in the address in support of the objection to the second and third respondent document, the petitioners raised the sole issue of whether, having regard to the said pre-hearing session report and paragraph 41.3 of the first schedule and decided cases, the documents tendered by the second and third respondents are inadmissible and liable to be expunged from evidence. Lanisel pointed out that Exhibit RA1 is a private document emanating from the third respondent and argued that in the absence of the narrow exceptions to the maker of the document, being the person to tender the document, the witness of the first respondent, thus RW1, cannot tender same in evidence. He relied on Main Street Bank Limited and General Steel Mills Others Limited. National Council also submitted that Exhibit RA2 is inadmissible because the first respondent cannot appropriate and reprobate at the same time. Since Exhibit RA2, the first respondent is trying to deny another letter received by it from the fourth respondent on 15 July 2022, which he had also certified. Then we just go direct to the resolution. So by virtue of the provisions of Section 102B of the Evidence Act 2011, public documents include public records kept in Nigeria of private documents. In the case of Onwuzurike and Idoziem and others, where the Supreme Court, Onogan JSC, held, as it was, held that a private document sent to the police form part of the record and of the police and is consequently a public document within the provision of Section 109 of the All Evidence Act, now Section 102 of the External Evidence Act 2011. It is also tried that a public document duly so satisfied is admissible in evidence, notwithstanding that it is not tendered by the maker. Indeed, a certified true copy of a public document can be tendered by a person who is not a party to the case. See the case of Maranro and Adebisi, Dagash and Bulama, Mustafa Ketima and others versus Al-Haji Bukar Customs. Exhibits RA1 and RA2, being in the public record of the first respondent, are public documents and are therefore admissible in evidence, having been certified by the first respondent under Section 104 of the Evidence Act 2011. On the petition objection to exhibits RA6 and RA7, the record of proceedings of this court of 4th July 2023 shows that contrary to the assertion of the petitioners, the said exhibits RA6 and RA7, which are the cloud trail log and certificate of compliance with Section 84 of the Evidence Act respectively, were not tendered from the bar, but through RW1. Indeed, the record shows that the petitioners consented to the said document being taken as read and demonstrated. We therefore have no hesitation in discountenancing the petitioner's objection to those documents. On the whole, the petitioner's objection to exhibits RA1, RA2, RA6, and RA7 tendered first respondents is unmeritorious. It is hereby overruled. We now go to objection to the petition objection to the second and third respondents' documents. We consider the the resolution without objection. On the petition objection to exhibits RA8 and RA9, an examination of the petition shows that in paragraph 28, they have challenged the second respondent qualification to contest the election on the ground that he was fined the sum of $460,000 for an offense involving dishonesty, namely narcotics trafficking, imposed by the United States District Court, Northern District of Illinois, Eastern Division. As rightly submitted by the second and third respondents, they have countered this allegation of the petitioners in paragraph 46 to 53, and particularly pleaded in paragraph 50 that the United States of America, through its embassy in Nigeria, had by a letter dated February 4, 2003, addressed to the then Inspector General of Police, and confirmed that upon their record checks of the Federal Bureau of Investigation, National Crime Investigation Center, NCIC, a centralized information center that maintains records of every criminal arrest and conviction within the United States of America. There were no record of any form of criminal arrest, warrants, or warrants against the second respondent. The respondents shall found and rely upon a copy of the said letter of February 4, 2023, signed by Michael, I think it should be 2003, signed by Michael M. Bonner. It is obvious that issues were joined by the party, and exhibits RA8 and RA9 are clearly relevant. As for the argument of the petitioner over the custody of the documents, Exhibit RA8 is a letter of inquiry written by by the Inspector General of Police to the Consulate General of the United States Embassy in Nigeria, inquiring as to whether the second respondent had any criminal record in the United States of America, while Exhibit RA9 is the reply to Exhibit RA8 by the United States and are therefore public documents under Section 102B of the Evidence Act. Certification by the Nigeria Police Force is a confirmation that Exhibits RA8 and RA9 are true copies of those documents which are in their custody. Onwuzurike and Idoziem, Abaje and Koka. With regard to the petitioner objection to the relevance of Exhibit R10, the record shows that the petitioner's challenge to the qualification of the second respondent was confined to allegations of double nomination of his running mate, the third respondent, and the alleged fine of the second respondent of the sum of $460,000 by a United States court. The educational qualifications of the second respondent were never challenged by the petitioners in this petition. It was the second and third respondents who introduced the educational qualifications of the second respondent in their reply, and the petitioners have not joined issues with the second and third respondents in their reply to the second and third respondent reply. It is right that the court of law adjudicates only on matters over which parties are in dispute. See Adedeji and Olosho and another, then Trade Bank PLC versus General of Nigeria Limited. Since there is no controversy or dispute between the parties as it relates to the second respondent educational qualifications, Exhibit RA10 is not relevant to determination of this petition. It is hereby discontinued. Our examination of Exhibits RA11 to RA16, which are data pages and visa pages in the second respondent Nigerian passport, namely narcotics trafficking, and in response to this allegation, the second and third respondents have denied same in paragraph 46 to 53 of their reply, and specifically pleaded those documents in paragraph 52 of their reply to the petition to show that the second respondent enjoyed an unrestricted right of ingress and egress to the United States of America, and access to the United States of America. It is therefore our considered view that Exhibits RA11 and RA16 are relevant to these proceedings, and the petitioner's objection to same is hereby discontinued. As for Exhibits RA17 and to do with the first petition's locus standi to present the petition in paragraphs 1A to M of their reply to the petition. However, we have already considered and determined the issue of the petitioner's locus standi whilst resolving the respondents' preliminary objections. We have already resolved same in favor of the petitioners. Therefore, this objection has been overtaken by our ruling on the preliminary objection. On the petitioner's contention that Exhibit RA19, the report of the committee on the location of the federal capital Nigeria, is not relevant. We have examined the plea the presidential candidate must score 25% of the votes in FCT before he can be declared and return elected. The second and third respondents have averred in paragraph 86 of their reply that the FCT does not enjoy a special status over the other states of the Federation, and that Abuja is still inhabited by Nigerians who are deemed equal to Nigerians in any other part of Nigeria, and residents of Abuja are not conferred with any privilege and advantage that is not accorded to citizens of other communities or states in Nigeria. We are therefore of the view that facts have been pleaded which rendered Exhibit RA19 relevant and admissible. On the petitioner's objection to the admissibility of Exhibit RA22, we observe that the document is the same as Exhibit RA2, which we have already found to be admissible, having been certified by ANEC as a copy of document in their possession. The tender of Exhibit RA22, which is not even certified, is therefore a surplusage and is hereby discontinued. With regard to the objection to admissibility of exhibits RA24 and RA25, which are CTCs of pages 20 and 29 and 37 of Nigerian Tribune newspapers, respectively. The reasons advanced for the objection of the petitioners are not legal grounds for challenging admissibility of a document. We have no hesitation in discounting the objection. Contrary counsel that Exhibit RA27, the ECOWAS preliminary declaration, is a private document. The said document forms part of the official record of the Economic Community of West African States, ECOWAS, an official body established under the ECOWAS Treaty. An agreement made by member states of the ECOWAS community, and the treaty was signed by heads of state and government of the 16 member states. It is undoubtedly a public document within the meaning of Section 102 of the Evidence Act 2011. However, observe that Exhibit RA27 is not certified as required by Section 104 of the Evidence Act to render same admissible. Not being so certified, Exhibit RA27 is hereby extant from the record. As for the objection to Exhibit RA28 being the American Bar Association membership card of RW2, which was tendered by RW2 under cross-examination by the fourth respondent, it is clear to us that the document was neither pleaded nor listed or referred to in the statement of PW2. As rightly argued by the petitioners, Exhibit RA28 is inadmissible. Accordingly, it is hereby expunged from the record. Now we go to the merit of the petitions. Having disposed of the various objections to witnesses and to some of the documents tendered in this petition, we now proceed to consider the merit of the petition. The parties filed, exchanged, and adopted their respective written addresses of the first, second, and third, and fourth respondent were filed on the 14th July 2023, respectively. On the 23rd of July 2023, 20th July 2023, and 23rd July 2023, the petitioners filed 3 separate final addresses in response to the final addresses of the first, second, and third, and fourth respondents, respectively. In reaction to the petitioners' final addresses, the first, second, and third and fourth respondents filed their reply addresses on 28th July 2023, 21st July 2023, and 28th July 2023, respectively. The first respondent and the second and third respondent also filed lists of additional authorities on the 28th and 31st of July 2023, respectively. On the 1st of August 2023, the parties adopted their respective final addresses. In his adopted final written address, Learned Senior Counsel for the first respondent, A.B. Mahmoud SN, distilled the following 5 issues for determination. A. Whether having regard to the provision of Section 131 and 137 of the Constitution of the Federal Republic of Nigeria 1999 as amended, and the evidence before the court, the second and third respondents were qualified to contest the presidential election of 25th February 2023. B. Having regard to Section 47, subsection 2 and 3 of the Electoral Act 2022, paragraph 38 and 92 of the regulations and guidelines for the conduct of the election 2022, the inability of the first respondent to transfer or transmit the results of the presidential election to the IRF portal real time. Amounted to non-compliance to Electoral Act, and whether such non-compliance substantially affected the outcome of the election. C. Whether by the totality of evidence adduced, the petitioners have proven that the election of the second respondent was invalid by reason of corrupt practices and non-compliance with the provisions of the Electoral Act 2022. D. Whether in the absence of any proof of lawful and unlawful votes to be added to the scores of the petitioners and or unlawful votes to be deducted from the second respondent's scores at the election, the petitioners have proven that the second respondent was not elected by lawful votes cast. E. Whether having regard to the declared results of the election and the provision of Section 134, subsection 2B of the Constitution of the Federal Republic of Nigeria 1999 as amended, the second respondent ought to have been returned as duly elected after having scored the highest number of votes cast with 25% of the votes cast in over 2/3 of the states in the Federation. The learned senior advocate for the second and third respondents, Chief Wale Olanipekun, formulated the following four issues for determination. One, having regard to the relevant provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended, the salient provisions of the Electoral Act 2022, the judgment of the Federal High Court in FAC ABJCS 1454/2022 between Labour Party and INEC delivered on 23rd January 2023, which is Exhibit X1, as well as admissible evidence on record, whether the election of the second respondent into the office of President of the Federal Republic of Nigeria on 26 February 2023 was not in substantial compliance with the principles and the provisions of the Electoral Act 2022. 2. In view of the clear provisions of the Constitution of the Federal Republic of Nigeria 1999, the Electoral Act 2022, and plethora of judicial precedents on the criteria for qualification of candidates for election to the office of President, coupled with the unreported decision of the Supreme Court in SC/CV/501/2023, People's Democratic Party vs. Independent National Electoral Commission, INEC, delivered on 26 May 2023, Exhibit RA 23, whether the second reading of Sections 134 and 299, as well as other as President of the Federal Republic of Nigeria. And 4, considering the constitutional petition and the task evidence adduced, whether this Honorable Court can accede to the reliefs being claimed by the petitioners. Prince L.O. Fabemi SN, Senior Counsel, the Senior Counsel for the fourth respondent, also nominated 4 issues for termination as follows. 1. Whether have Nigeria 1999 as altered. 2. Whether having regard to the same, still the following 3 issues in the petitioner's final address. The second and third respondents are qualified to contest the presidential election by reason of the unchallenged facts and circumstances arising under Section 133 to 1999